Joe Carlin is suing his ex-wife Mary Stepp because she failed to honor their agreement to pay for half of their daughter's karate lessons.
Order, all rise. Order in the courtroom, please, all rise. Your Honor, this is case number 293 on the calendar in the matter of Carlin versus Stepp. Parties have been sworn in, Judge. You may be seated. Ma'am, have a seat.
Mr. Carlin, you and the defendant have been divorced for many years.
Yes, ma'am.
And according to your complaint, you shared custody for most of those years of your now 16-year-old daughter.
Yes, ma'am.
Yes. And it sounded as if everything was going along reasonably well, right? Until you gave your consent while your daughter was with you to have her lip pierced.
Yes.
A decision which I gather, reading between the lines, you regret a little bit.
Slightly.
And as a result of that, Mr. Carlin, I get the sense you filed this lawsuit, which alleges that your former wife had agreed to pay for half of your daughter's karate lessons.
That's correct, Your Honor.
And she became rather expert in karate. She took karate for several years. Your former wife had not paid for half.
That's correct.
Something that I don't think bothered you too much until the lip piercing.
No, that's not correct, Your Honor.
Well, this whole thing didn't blow up until the lip piercing. Is that right?
That's correct.
And then something happened that, as far as I'm concerned, was tragic, but we'll get to that in a moment. So why don't you tell me when this agreement was made with your former wife?
About 3 years ago, Sarah was shopping around. She was interested in taking karate. So she looked at one school, and she looked at another one, and she liked the second one. It wasn't as expensive as the other one, and as a matter of fact, it was a little bit cheaper, but they wanted the money up front, basically over a 10-month to a year period. It came out to a little over $4,100. I talked to my wife, Teresa, and she said, we cannot afford this. I said that Sarah's mother would agree to split it with me. I picked up the phone, I called her, I laid this out to her, exactly how they wanted. I didn't expect the money right up front from her, but she said that she would split the cost of the school. 2.5 years later, 3 years later, I've yet to get a dime.
You remember having the conversation with him
No,
when your
Your
daughter
Honor.
started school?
No, Your Honor, I don't.
He says that he did discuss with you when she first started karate school, make sure you tell me the truth, that he wanted you to pay for half because he couldn't assume the entire burden of the classes. Now, are you telling me that he's lying?
Yes, I am, Your Honor. That's not true. I never saw one document from the karate school. He never approached me about paying half the money. We split tokens. He would pay tokens 1 week, I would pay tokens for school. The karate lesson money was never brought up.
Okay. Now, something happened with your daughter recently, I assume, when she came to you and said she wanted to have her lip pierced. Tell me about that conversation.
Well, for 2 years, she had wanted to get something pierced. She has about 3 holes in her ear, and I was like, no more, no more. And when she was 16, we had discussions. She asked and asked and asked, and finally I broke down.
Did you discuss it with her father?
No, I didn't.
Why not?
It really wouldn't have been a big deal.
All right. Mr. Carlin,
Yes, ma'am.
then you saw your daughter. I must tell you, I am sympathetic with you as a parent. You see your gorgeous daughter, and she's got this ridiculous thing in her face, and you got really angry.
That's correct.
So what did you do?
Well, Sarah and I had discussions prior to this that she was getting a little tired of the shared custody arrangement. So I picked her up and saw the stud, and I couldn't believe it. I took her down the next day to the place where she had it put in, and I let them know that she was only 16. I want this thing out now. And she refused to come in. So I took her back to her mother's house, and I said, you're tired of this shared custody arrangement? I said, I can't have this, either. And that was it. She's been with her mother since July 15th.
Mr. Carlin, you're going to answer me very honestly, sir.
Yes, ma'am.
Because I think you've been a good father. I think you've been an involved father, good parent. Do you believe, Mr. Carlin, that your reaction to your daughter's piercing was appropriate?
At the time, yes.
Now, at the time, yes, because you're a human being and you have, you know, the juices started to flow. In retrospect.
No, I think I could have handled it a little bit differently, but like I said, you know, even Sarah agreed that she shouldn't have gotten this thing, and she even went down with me to the place where she got it pierced at to get it out. But when we got there, she made a stance that I'm not going to do it, Dad. And I said, well, then we just can't have this shared custody arrangement anymore.
Excuse me, Your Honor. She didn't want to go down to the piercing place. He made her go down, and when she wouldn't get it out, he dropped her off at the corner of my street and said, get out, in no uncertain terms. They had no discussion over the shared custody thing outlasting itself. The term was, get out.
Judge Judy continues in a moment.
As long as I pay the bills, I want to be able to look at you unencumbered by things coming out of your face and your ears.
And later today,
never get in the middle of two people who are getting a divorce.
They never got along. He can't stand her.
That's very understandable.
real cases, real people. Judge Judy. Joe Carlin says his ex-wife Mary Stepp agreed to pay for half of their daughter's karate lessons. Mary claims they never had such an agreement, and Joe is angry because she allowed their daughter to get her lip pierced.
A judge is not a computer. A judge is a human being, and we bring to our job all of our history, you know, all of our own personal stories. So I'm going to share one with you, all right? I have 5 kids, and they're all older now. When one of my children started college, and this was 14, 15 years ago, he came home from school after his first couple of months, and I picked him up at the bus station, which was pretty far away from our house. And he was coming home with a friend. And he got off the bus, and I looked at this handsome child, and he had something wangling from his ear. So I kissed him hello. And I said, you can get in the car. That thing stays outside. Oh, Mother, don't be ridiculous. You know, everybody's doing it. I said, listen, I don't have to look at it. I brought you into this world. I still pay the bills. As long as I pay the bills, I want to be able to look at you unencumbered by things coming out of your face and your ears. He thought I was kidding. I said, you got 5 minutes, boy. And he hung around, he spoke to his friend, and they were trying to figure out whether I was serious or not. 5 minutes passed, the thing wasn't out of his ear. I got in my car and I went home. And about 2.5 hours later, because it took that long by public transportation, you know where this was? This was in the Bronx, where he was in the Bronx, all the way up in the Bronx, where the bus came in from Albany, Bronx, New York. He managed to find his way home without the earring in his ear. Now, that doesn't mean when he was in college, he didn't have rings and ropes and dangles and doodads hanging out from every orifice of his body. But I didn't have to look at it. So you didn't do the right thing, you know. You're supposed to be a parent first and a friend second. And a parent says, babe, you got a couple more years until you are 18 years old. Then I can't tell you what to do. Right? You want to paint polka dots on your face, you can paint polka dots on your face. But while you're in my house, I don't want to have to look at this thing here. I don't want to look at something in your tongue. I don't want to look at something in your nose. I just don't want to see it. He didn't do that. That really irritated him. Right, Mr. Carlin?
That's correct, Your Honor.
Okay. So the problem is this. I find it difficult, Mr. Carlin, to imagine that 3 years have gone by with you taking no action whatsoever, even to get $100, $200, and have done nothing over the 3-year period of time to recoup any money if you say that there was this verbal agreement. I have a problem with that. So I'm going to take care of the lawsuit right now. I'm not satisfied that you have established to my satisfaction that there was this contract.
Your Honor, child support is more than just a check in the mail each week. There's
Sir, if that's
parental
what you're
support.
banking on, I'm telling you, it doesn't hold water. Karate lessons don't come under the category of necessaries for anybody. So I'm not, if that's what you're hanging your hat on, forget it. More importantly, Mr. Carlin, you have invested 16 years in your daughter. And I think it's a mistake to cut her off after 16 years because she, as a 16-year-old, made a foolish mistake. Big mistake, Mr. Carlin. I want you to rethink it. In any event, this lawsuit is dismissed. That's all.
Parties are excused. You may step out. Out the back door to your right, please.
I took care of her.
Not one
From a-
phone call
from an
since July 15th. Not one phone call. Nothing.
Sarah don't know how to use a phone.
Your duty's to call her at 7
Oh,
o'clock at
that's
night.
my duty.
Yeah, you're the
duty.
father. She's a child.
She's 16 years old.
Great, great.
She's 16 years old. She can make up her mind.
And now the next case.
Parties on Lehman versus Morris. Step forward, please.
22-year-old Kelly Lehman says she made a deal with her best friend April Morse to take over the payments on her truck and pay for repairs. She's suing because April's ex-husband, James, repossessed it.
It's not every case that has a moral. This case has a moral. You know what that is?
Yes.
You know what the moral is?
Don't do business with friends.
That's one, but the other one would be never get in the middle of two people who are getting a divorce. It's always a mistake, right? Ms. Lamont, according to your papers, the defendant was a friend of yours. She and her husband were divorcing. You the husband?
Yes.
And I'm sure in addition to other things, there was a truck that they wanted to sell, or that she wanted to sell. There were payments due and owing on the truck. You made an arrangement with her to take over the payments on the truck and to do substantial repairs that were on the truck.
Correct.
You paid the money for the repairs. You didn't have the truck in your possession at that
No,
time.
I did not.
The truck is in the shop,
Correct.
and you kept paying.
I made one payment
In August.
in August. Correct.
And according to these papers, for most of the month of August, the truck was still in the shop.
Yes.
And you're going to tell me why you did that in a minute. And then, in the divorce, according to your answer, he got possession of the truck, and he came and took it out of her driveway. Is that this case?
Well, it was parked on the street.
Or took it from the street? So you want to be paid back for all the repairs you did on the truck, for the payment that you made on the truck, and then there's something here about punitive damages, which is really nonsense.
Judge Judy continues in a moment.
We started getting in a fight after her boyfriend said that he was attracted to me after we had gone out one night together.
Real cases, real people. Judge Judy. Kelly Lehman says she made a deal with her best friend April Morse to take over the payments on her truck and pay for repairs. April and her ex-husband James say they repossessed the truck because Kelly made the payments late.
So let's hear about this deal.
Okay, well, April and I have been friends since the first day of high school. I needed a more dependable vehicle. She had it. I said, okay, we made this arrangement. At the time when the payment came due for the August payment, I didn't want to make it. I didn't have the truck. Why should I make it if I didn't own it?
Why do you think she should have made payment on the truck if the truck wasn't in her possession?
It was her agreement with me that she would make that first payment. And we thought that the body work that needed to be done would be done a lot sooner.
But it wasn't. Didn't it seem unfair to you that she had
It wasn't
made
my fault.
hundreds of...
It wasn't my fault that she agreed to make the payment.
But didn't it seem unfair to you? This is a friend of yours. Didn't it seem unfair to you that you had this truck that needed all kinds of repairs in order to make it drivable? Because there's stuff that was needed on the clutch and the bodywork and the muffler, things that she didn't know about at the beginning.
She knew about everything, and it was her choice.
The muffler was never told that it needed a new muffler.
Yes, it was. Yes, it was.
Don't... Hey,
I was never told that the windshield was cracked. I was never told that the truck had actually been rolled and that there was more damage to it than that was apparently done to
well,
it.
the
truck wasn't rolled.
Gives you another good lesson.
Right.
You don't buy a pig in a poke. If you're going to start spending money on something, you take a look at it, even if you're dealing with a friend. So you made the August payment.
Late. She made it late when she promised to make it on time.
She made it late, but at the time that she made it, she still didn't have the vehicle in her possession.
That wasn't my fault, though. But she didn't have a problem with it.
Whose fault is it? It wasn't my fault, madam. The truck was in your possession, under your control when it was damaged. Wasn't under her control when it was damaged.
She didn't have a problem with making that payment until we got in a fight over her boyfriend.
How much did you spend on this truck altogether?
Oh, I've spent a total of $1,053.38.
$1,053.
And 38 cents.
38 cents. And that includes the bills that you have to show me for the repairs, as well as the 1 month's payment for August. You don't deny that she paid you this money?
I don't know what she's giving you.
Okay, show it to her.
At the time that the repairs were being done, I was told it would be a matter of days when I had given her the money, and it ended up taking like 2 weeks.
And that was not my fault. I kept mailing checks to the body shop, and they kept telling me they didn't receive them.
It's always somebody else's fault. You keep saying it's not my fault, it's not my fault, it's not my fault. It's not her fault. You, step up here, I have a question for you. What's your name?
James.
James, you went and took the truck off the street.
Yes.
Did you know she had made all these repair payments? Look at me, James. Don't look at the floor. Did you know she had made all the repairs?
Yeah.
Well, didn't you think it was wrong to go and take the truck?
No.
Why not?
She didn't do everything she said she was going to do.
You're talking about this September payment that you didn't make on time. You repossessed this truck from her September 12th.
By the law,
No,
you
not
have to have
September 12th.
insurance on the vehicle. She didn't have insurance on the vehicle.
Did you ever discuss it? I mean, you were friends. Is that right?
Jim was
They
not
were
even
friends.
involved.
Just a second. If you were friends with her, that means you knew each other. You had socialized in each other's homes. Your children played. Is that true?
Kind of.
They never got along. They never got along.
I
He
could
can't
understand
stand her.
that. That's very understandable.
Judge Judy continues in a moment.
Well, right now, she's out all this money, and you got the truck. And you were awarded the truck in the divorce, sir. Is
Yes.
that right?
That's right.
How many cars did your family have?
2.
2. You had the truck, and what kind of car did you have?
A Ford Escort?
Uh-huh. So you agreed between the two of you that you would keep the Escort and he would keep the truck. Is that correct?
But we also agreed that if she made the payments on time, as soon as our divorce was finalized, that we would sign and let her refinance the truck. But after we got in a fight, she didn't want to refinance. She said, I'm going to do what I want. There's nothing you can do about it. You can't take the vehicle from me. She refused to get insurance until it was in her name. Therefore, she's driving around a vehicle that we owe a lot of money on still. She did not make the, okay, granted, give her the first month. She did make payment on time. If you say she didn't have the vehicle, even though she agreed and it wasn't my fault, the second month, she came up with an excuse. I don't have the money. I can't make it till it's late. She breached our agreement first. And when he took the truck, he took it on his own. I had nothing to do with it. The
Ms.
payment was
Morris,
late.
right now there is something inequitable about you having a totally fixed truck and her having nothing but the bills.
No. We offered to make her payments. They wouldn't accept it. They wanted all the money up front.
She paid all of it up front, $1,053.38. Can I have the bills, please?
She didn't
make it in
I
payments?
don't agree with all of this.
Miss Morris, I don't care what you agree with. There is something
You asked
inequitable.
Me, you asked me.
Hey,
I'm telling you.
now I'm asking you to be quiet. You, sir, are driving around in a truck where she fixed the bodywork, she fixed the clutch, she fixed the muffler, she fixed the windshield, and you got
She
a
didn't
brick.
fix the
She didn't
windshield.
fix no windshield.
Strike windshield. And you're driving around in the truck. You should have taken care of this yourself. Judgment in this case is for the plaintiff in the amount of $1,053.38. That's all.
Parties are excused. You may step out. I'll back to your right, please.
Judge Judy continues in a moment.
Parties on Peraza versus Barraza. Step forward, please.
Myra Peraza says she and her former best friend, Tina Barraza, won a new Jeep in a raffle, but Tina refuses to share it. Tina claims it was her ticket that won the Jeep, making her the sole winner.
Order. All rise. Quiet in the courtroom, please. Now, this is case number 301 on the calendar in the matter of Peraza versus Barraza. Parties have been sworn in. Judge, you may be seated. Have a seat, ma'am. Ma'am.
You two gals are real good friends. You went to some sort of an event, which you're going to tell me about. one of the things that happened at that event was that there was a door prize of a brand new Jeep automobile, right?
Correct. Yes.
She won, you think that you should get half, right?
No, not exactly.
Well,
I think we both won.
you think you both won, and she claimed the prize.
Yeah, she ended up going behind the back and claiming the prize.
All right, let's start from the beginning. What kind of an event was this?
It was just an event from a radio station and Taco Bell. It was just a concert.
Slowly.
It was just a concert. It was just a concert where these rappers are going to be there or something like that.
You, according to your complaint, got the concert tickets and asked her if she wanted to go.
No, she got the concert tickets.
She got the tickets?
Yeah, and she asked me if I wanted to go.
Okay.
And I agreed, and we went, and at the door, they asked us if we wanted to gamble, and we said yes, and they gave us $500 fake dollars each.
Did you have to pay for that?
No. No, they just asked us at the front, if you wanted to gamble, you got $500. If you didn't, well, you didn't gamble.
So it was like Monopoly money?
Yeah, I guess, yeah.
Okay.
And after that, she asked me, I mean, I was there with her the whole time, but then she asked me if she could gamble my money, and I said, sure, go ahead, you know. And she's like...
You weren't gambling?
No, I was just standing right there, just helping her out. That was about it. She gambled, she got all my money, she gambled it away, and we ended up getting chips for, just chips, regular chips are what you gamble with, and when you were gambling, so we had to trade those in for tickets. And after that, some guys just came up to us and told us that, oh, they were leaving, they were in a rush, so they came over and they gave us their tickets. They said, here, girls, good luck, and if you guys win, give us a call.
So now you had these whole bunch of tickets, and you threw them in a pot.
We just, yeah. That was,
Who held on to the stubs?
I did.
You did?
Yes.
Okay.
yes, it was, she had it in my backpack, so she put it in the backpack. We had a backpack, it was only one, so she put them in there.
And you had a whole bunch of them. How many did you have?
There was probably 50 or probably more. I wouldn't know. We didn't count them. And we just threw them inside the backpack, and it was time for them to call out the tickets. The time came, so we went down there, and they started calling out tickets. We won other prizes. Prior to that, we won something else, and it was time to call out.
What else did you win?
We won a jacket and a backpack. And
what'd you do with that?
one of us kept the backpack, and the other one kept the jacket.
Is that right?
Yes.
Go ahead.
So I guess the time came to win the thing, and we just got the tickets, and she's like, here, you take half, because there was so many of them. We just split them up. She said, you take half, I'll take the other half. And
to look at the
them,
numbers as they were calling the numbers.
Yeah, so then after that, they called the number. That was about it. They called
And
it.
you had the ticket. You were holding that ticket.
Yeah, she was holding the ticket.
Okay. Now let me ask you this question. I'll ask you this question. There came a time when you did split up these tickets, right? She held half and you held half. Tell me about that moment.
As I recall, we just split them up.
Not
just
we split them up. They're in your hands.
Okay, I split them up evenly.
Split them up evenly?
Yes, I just gave her half, and, we both looked at them.
Okay. Am I correct that your reason that was done was because it's too difficult to look at all the numbers as they're calling out the numbers, like in a bingo or something,
Yes.
so that each one of you was looking through half,
Correct.
right? And your ticket won.
Yeah, they were my tickets. They were all my tickets.
Now, why do you think they were all your tickets?
Because she had given me her $500. I did not ask her if I can play with her $500. She gave them to me. She gave the $500 to me.
How did that come about?
She said, here, take my money. You can gamble with it.
Is that what you said?
No.
No, that's not what happened.
That's exactly what happened.
No, we were gambling. She ended up, she was like down to her last $50, and she just said, can I, let me have your money. And she said, if we would win the Jeep, we would split it up.
I had said that from the guys' tickets. I had the guys' tickets in one hand, and I had my tickets in the other hand, the ones that I had won.
No, you didn't.
Yes, I did.
No, you didn't. All the tickets were together in your backpack at one point. Oh, I think that they probably were. All the tickets were together in your backpack.
At one point, I had put them all together, yes.
Right. So at that point, they were all mixed together.
Yes.
Yours and the guys.
Yes.
Right. So there really is no way of knowing whether it was your ticket that won or the guy's ticket that won.
Exactly.
Well, now at least we got that straight. So it's not in one hand and then the other hand.
But I had told her, out of
their tickets that they gave us. Actually, they gave me the tickets. And I told her out of those tickets, if we win it, we'll split it because we were friends.
You couldn't tell whether it was their ticket that won.
No, we could not.
You just assumed it was comfortable for you to say it wasn't one of their tickets that won, it was my ticket that won.
I did not say that.
You had no way of knowing whether it was your ticket that won or one of the guys' tickets that won.
Mm-hmm.
Right?
Exactly.
Am I dealing? Hello?
Judge Judy continues in a moment.
You speak to this pain in the neck, and a 12-year friendship is down the drain over a Jeep.
And later today,
he had stolen my daughter's clothes before. I also have sex letters where he signed up for sex calls. And I have pictures to prove what kind of person he is.
real cases, real people. Judge Judy. 19-year-old Myra Barraza is suing her former best friend Tina Barraza after they won a new Jeep in a raffle.
I see that you have a tape there. Can you tell me what that tape is of?
This is just the day of the event, recorded us, where we both claimed the prize. We both did go up there and claim the prize. And
For the Jeep?
Yes.
I want to see it. Well, that certainly looks as if, at least at that moment, there was a mutuality that each of you won that prize. So what happened?
I was willing to split with her.
So?
And that's what we were going to do until about a month later. She had called me up, and she had said that she wanted to give it to me. She said, go ahead and have it, in other words.
Where was it?
I hadn't got it yet.
Did you do that?
No, I called her up. There was all this stuff was going on with the Jeep. We didn't know what we were going to do. It was a big old thing about it. We didn't know how we were going to split it up, who was going to pay for tax and license and everything. And we were going to get the confirmation letter. And I called her up and I told her, yes, you could stay with the Jeep. But she had said if she stood with the Jeep, she was going to give me an $8,000 loan. That's how much the car was worth, $16,000.
I did not state that.
And I told her, okay. She said she was going to tell her dad, sell her other car that she had just bought, sell it back, and instead of paying $15,000, she'll just tell her dad to get an $8,000 loan and pay me for it. And I said, okay. We agreed. I never thought anything. I just said, okay. It was just a verbal thing, but I did tell her, okay, you could keep the Jeep, and
that sounds reasonable because you can't split up the Jeep.
Yeah, and I just said, okay. And I said, you could pay my $8,000, or else we're just going to sell the Jeep, and we're both going to get our half.
No, she did not say that on the phone. She told me that she wanted me to keep the Jeep. That's what she told me.
What? Of course, that's what she said to you.
Yeah, but she did not specify that she wanted me to give her $8,000.
Well, why would she make you a gift of $8,000? If the Jeep is worth $16,000, why in the world do you think, madam, that she would make you a gift of $8,000, which is half of the Jeep? Why?
I don't understand what you're saying.
Well, let's go slowly. What word didn't you understand? Why do you think that she would make you a present of $8,000?
She did not say anything about $8,000. I did not hear anything about $8,000 on that telephone call. At that time, I was like happy. I was happy that she'd given it to me. And I figured that
what are you doing standing up here?
I want to step in for the spot where she told me through everything that happened. She called me every time they had a conversation. She was asking me, what should I do? What should I do? What do I do about the Jeep? Do I split it in half? Should I sell it? What? I told her, you know what? You won the tickets to that concert. It's your Jeep. You were holding the ticket at the time she won it.
Oh, you're the troublemaker. Sit down. Sit down.
As I was saying, I figured the reason why she said that on the telephone is because she knew that she did not have any part in the ticket winning.
Oh, please, madam. I want to tell you something. I think that your conduct was really outrageous to bring it to this point. First of all, the two of you have been friends. There isn't a question in my mind. What?
9 years. 12 years.
There isn't a question in my mind, after looking at that tape, that at the time that that Jeep was won, the two of you, both of you, I saw her signing papers.
We didn't sign any
Just
paper.
a second.
It was just a back of a flyer. We put down both our names and addresses.
Right. It was the back of a flyer. You both put down your names and addresses as the winners. Right?
Yes.
That's what it looked like to me on there.
Mm-hmm.
And then sometime you speak to this pain in the neck who says to you, I don't think you have to split it with her at all because it was your ticket, it was in your hand. And a 12-year friendship is down the drain over a Jeep because there is no logical reason that I can think of, except if you're drinking too much, to think that this lady would call you up and say, I just want to give it to you because you're a very nice person. I care about you.
No.
Please.
Judge Judy continues in a moment. And later today...
That's called the Soddy principle, S-O-D-D-I. Some other dude did it.
I was driving my horse trailer down the gravel road to my family's ranch after 4 months in Washington, D.C., when red and blue lights sliced through the Texas sunset. 3 squad cars blocked my gate. And there she stood, Karen Whitmore, arms crossed, that victorious smirk plastered across her face like she just won the lottery. She was actually bouncing on her toes behind the officers. The deputy approached my truck, hat in hand, looking like he'd rather be anywhere else. Sir, we've got a trespassing complaint. This lady says you don't belong here. I glanced at Karen, then at the iron sign reading White Hawk Ranch, ST 1887. Then I looked back at this woman who had moved into the new subdivision just 3 months ago. Diesel exhaust mingled with the scent of sagebrush. Cattle were lowing somewhere in my back pasture. Officer, I said calmly, meet the woman who just called the cops on the guy who oversees every HOA in America. Karen's victory smile melted like ice cream in August. What would you do if some HOA busybody tried to get you arrested on your own family land? Let me back up and tell you how we got here. My name is Garrett Whitehawk, and 4 months ago, I buried my father on the same Texas soil his grandfather broke with a plow in 1887. We have 2,400 acres of rolling hills, mesquite, and the finest cattle operation in Millfield County. Dad left me more than land, though. While I was running cattle and fixing fence, I'd been working my way up through the Federal Housing Administration. When the old man passed, I got called to Washington, D.C. for a promotion, Regional Oversight Director for the Federal Housing Authority. My job? Making sure HOAs across 5 states follow the law. The irony was about to become delicious. While I was learning how to investigate crooked HOA boards and development scams, my foreman, Buck Henley, was dealing with our new neighbors, Sagebrush Estates, a fancy subdivision marketed as an authentic Western living experience. Translation: California transplants paying premium prices to live next to real cowboys, then complaining about everything that makes it authentic. Enter Karen Whitmore, 48 years old, fresh from some HOA civil war in San Diego, who appointed herself Neighborhood Compliance Coordinator before her U-Haul was unloaded. Buck described her perfectly. She's got the energy of a caffeinated chihuahua, twice the bite, and about half the sense. Karen's first week, she drove by our ranch twice daily with a measuring tape, clipboard, and the determination of a health inspector at a roach motel. Buck caught her photographing our cattle through fence slats, actually taking notes on their bathroom habits like she was writing a dissertation on bovine waste management. The complaints started immediately. Certified letters piled up faster than manure in a feedlot. Excessive agricultural odors. Apparently, cow manure doesn't smell like roses. Unsightly equipment storage, because tractors are so offensive. Noise violations from livestock operations. Cows moo. Who knew? All filed with Millfield County by concerned citizens, which translated to Karen plus whichever neighbors she'd terrorized into submission. Buck kept me updated through scratchy phone calls to DC boss. This woman's documenting everything. Timestamps our feeding schedule, measures dust clouds with some fancy meter, even called the county claiming our access road violates her property setbacks. Here's the beautiful part. Her house sits 50 feet from our fence. Our cattle road's been there since Sam Houston was in diapers. But suddenly, it's a traffic hazard incompatible with her residential character. I came home to 17 complaint letters and one memorable introduction at Kowalski's feed store. The smell of grain dust and leather oil hit me like a warm hug. Then Karen cornered me by the horse supplements, extending a manicured hand like we were meeting at some ritzy charity auction. You must be Mr. Whitehawk. I'm Karen Whitmore, community standards advocate for Sagebrush Estates. Her smile was all porcelain veneers and zero warmth. We simply must discuss modernizing your operations to fit our neighborhood aesthetic. Behind her, old Marty Kowalski pretended to organize salt licks while clearly enjoying the show. The crunch of my boots on scattered feed echoed in the sudden silence. Ma'am, I said, keeping my voice calm as a Sunday morning. This ranch has been here since before your neighborhood was a fever dream in some developer's head. Oh, I completely understand the historical significance. She trilled like she was explaining multiplication to a kindergartner. But times change. Property values, you know. I have extensive experience with municipal compliance and valuable connections in county planning. I'm confident we can find solutions that work for everyone. The way she said solutions made it clear she meant surrender. For 20 minutes, she talked about community harmony and appropriate land use while I bought cattle mineral and listened to her redesign my family's century-old operation. She never once asked about our history, our legal rights, or whether we gave a damn about her dinner party schedule. She just assumed we'd roll over because Queen Karen had spoken. That night, I sat on the porch where 4 generations of White Hawks had watched storms roll across these hills. Lightning flickered on the horizon, and I could taste rain in the air, metallic and electric. The county had scheduled a neighborhood compatibility hearing based on Karen's complaints. She wanted our cattle road moved, our equipment screened from residential view, and our feeding schedule changed to accommodate her social calendar. I sipped bourbon and smiled. Storm coming, all right. Karen Whitmore just didn't know she'd picked a fight with the one guy in America who could shut down her entire HOA with a phone call. Karen didn't waste time. Within a week, she'd transformed from a solo complainer into the general of a 3-person army. Meet the Sagebrush Estates Property Values Committee. Sounds official, right? Her lieutenants, Bryce Kellerman, a retired bank manager who counted pennies like they were endangered species, and Donna Hutchkins, a former Phoenix City Council member who'd moved to Texas to escape the very bureaucracy she'd helped create. They held their first emergency meeting at Karen's kitchen table, complete with matching folders and a PowerPoint presentation titled Agricultural Operations Impact Assessment. I'm not kidding. Buck's security cameras caught Bryce arriving with a laser pointer and portable screen like they were planning the D-Day invasion instead of harassing a cattle ranch. Then came the beautiful irony. Karen decided to research me online and found my federal position as a regional oversight director. But here's what made me chuckle into my morning coffee. She completely misunderstood what I do. In her mind, I was some corrupt government lackey who oversees ranch inspections and protects agricultural interests. Perfect, she announced to her committee, her voice carrying across the evening air to Buck's listening post. He's obviously biased toward ranchers. We'll go straight to Washington over his head. I have connections in municipal planning. If she only knew those connections were about to become very interested in her HOA's compliance issues. While Karen plotted my professional destruction, I was quietly building her legal grave. My attorney, Sarah Olivia, ran a title search that revealed something delicious. I remembered my grandfather explaining these protections when I was 12, watching him argue with some long-forgotten developer. Agricultural easements are permanent legal shields that protect existing farm operations from future residential complaints. Every noise complaint Karen filed was actually strengthening our case by documenting our historical activities. The principle is simple: you can't move next to a farm, then complain about farming. The real treasure? Karen's previous addresses revealed a pattern clearer than cattle tracks in mud. 3 states, 4 communities, identical neighbor disputes. I called her former neighbor in San Diego. "Oh God! You got Karen?" Mrs. Rodriguez laughed until she snorted. She tried to get our mariachi band arrested for cultural noise violations. Called immigration on our gardener. Filed 17 complaints about our dogs barking. We have a cat. Karen's campaign escalated beautifully. She hired an Austin law firm specializing in nuisance abatement. Fancy words for legal bullying. The smell of expensive trouble wafted through their demand letter like overpriced cologne. They threatened lawsuits for diminished property values and demanded immediate cessation of incompatible agricultural activities. Her documentation project reached obsessive levels. Karen measured noise with a decibel meter during our 6 a.m. feeding routine, the electronic beeping echoing across the pasture like some demented alarm clock. She photographed every cow pie within 50 yards of her fence. Buck caught her standing on a ladder, taking aerial photos of our equipment yard like she was conducting military reconnaissance. The community rallied faster than horses to grain. Marty Kowalski banned Karen from his feed store after she demanded to inspect our delivery trucks. Rita Sandoval, who runs the county's best diner, told Karen her dress code suggestion for customers could be filed under places the sun don't shine. "That woman," Rita said, sliding coffee across the scarred form counter, "complained about my chicken and dumplings being too ethnically aromatic. In Texas, the audacity could choke a horse." The sound of Rita's coffee pot hitting the burner punctuated her disgust like a judge's gavel. Karen's legal team escalated with their first official demand: cease cattle operations within 200 yards of residential property, relocate equipment storage, establish sound barriers for livestock areas. The cost estimate? $340,000 in ranch modifications to accommodate neighbors who'd moved next to an existing operation. She organized a Facebook campaign called Millfield County Rural Reform, posting professionally photographed evidence of our violations. Half her photos showed normal ranch activities that had been legal since before Texas statehood. The other half documented our cattle doing revolutionary things like eating grass and existing while being cows. The entertainment peaked when Karen measured our fence height with a surveyor's rod, documenting potential sightline violations. Bessie, our most social heifer, wandered over to investigate this strange human behavior. Karen shrieked like she'd encountered a grizzly and ran for her SUV, abandoning expensive equipment in her panic. "Boss," Buck called, chuckling. "I got video of our neighbor being chased by a 1,000-pound cow who just wanted to say howdy. This beats cable TV." The county scheduled our neighborhood compatibility hearing for next month. Karen was confident her charts, graphs, and multimedia presentation would prove our ranch was an anachronistic nuisance, incompatible with modern residential development. What she didn't know: I'd already spoken with Marcus Webb, the county planning director, and Dad's old fishing buddy. Marcus reviewed our agricultural easement and laughed until coffee came out of his nose. "Garrett, this woman's complaints are legally meaningless. Your protections predate her subdivision by a century. But let her have her hearing. It might be educational for everyone involved." Karen thought she was building a case against us. Actually, she was documenting exactly why agricultural protections exist and why HOAs can't override century-old property rights. Karen's war machine kicked into overdrive. She launched Millfield County Rural Reform with a professional website featuring dramatic photos of our ranch operations. Cattle grazing apparently qualified as visual pollution in her world. She contacted Channel 7 about outdated agricultural exemptions hurting innocent homeowners, and organized a petition drive demanding ranch modernization requirements. The woman was thorough, I'll give her that. She even discovered our property tax records and filed a complaint claiming the ranch was underassessed compared to residential properties. The smell of bureaucratic meddling hung in the air like diesel exhaust on a still morning. But here's where Karen's amateur detective work backfired spectacularly. She found out I owned mineral rights under a portion of her precious subdivision. Information that's public record if you know where to look. Most people don't understand that in Texas, mineral rights often stay with original landowners, even when the surface land gets developed. Karen assumed this gave her ammunition against me, threatening to expose conflicts of interest to my federal supervisors. She had no clue that owning mineral rights actually strengthened my legal position while her complaints were building a beautiful case for harassment. Watching someone dig their own grave with such enthusiasm was almost painful. I responded with the patience my grandfather taught me when dealing with spooked cattle. Calm, steady, and strategic. Sarah Olivia began documenting Karen's harassment pattern for a potential restraining order. I continued my federal HOA oversight training through online modules, learning fascinating details about communities that failed to meet development obligations. The ranch community rallied like neighbors should. The Ranchers Association offered legal fund assistance, though we didn't need it yet. Millfield High School's FFA chapter wrote a letter supporting our operations. Those kids understand agriculture better than most adults. The Chamber of Commerce passed a resolution backing agricultural heritage, and 3 subdivision residents privately apologized, distancing themselves from Karen's crusade. Karen's next move revealed just how disconnected she was from Texas law. She attempted to get our ranch declared a public nuisance through a city council petition, apparently unaware that Millfield city limits ended 2 miles from our property. The public meeting where she presented her case to a confused council became local legend. "Ma'am," the mayor explained gently, "we have no jurisdiction over county land. You might want to research municipal boundaries before filing petitions." The room's collective whoa was audible, but Karen doubled down, claiming I was intimidating residents through threatening behavior. Her evidence? Security footage of cattle grazing peacefully in our pasture. Meanwhile, Sarah Olivia's investigation uncovered something delicious. The subdivision developer had cut corners on environmental impact studies, and original permits required a 200-foot agricultural buffer that was never implemented. Karen's house sat 50 feet from our property line, violating original development conditions. Even better, the county inspector found multiple HOA violations throughout sagebrush estates. Unpermitted fences, drainage issues, and buildings that exceeded height restrictions. Turns out Karen's community had bigger legal problems than cow manure smells. The irony kept building. During one of my federal training sessions about municipal compliance, I learned that HOAs managing developments built with any federal funding or tax incentives fall under oversight jurisdiction. A quick records check revealed Sagebrush Estates had received exactly those benefits during construction. Karen scheduled a community meeting at the subdivision clubhouse to present evidence against our ranch, inviting local media without consulting other residents. The taste of impending justice was sweeter than Rita's peach cobbler. Buck security cameras captured Karen's daily reconnaissance missions, photographing our cattle through fence slats, measuring dust levels with handheld devices, and documenting feeding schedules like she was preparing for war. The woman had turned harassment into a full-time occupation. "She's out there again," Buck reported one morning, taking pictures of the bulls. "I swear she's got more documentation on our cattle than the Department of Agriculture." The community meeting arrived with all the drama Karen could have hoped for, just not the kind she expected. 15 residents attended, mostly out of curiosity rather than support. Karen presented her slideshow with dramatic music and professional graphics, detailing every alleged violation our century-old ranch committed against her 3-month-old sensibilities. Then I arrived, uninvited, but perfectly within my rights as a county resident. Karen's face cycled through surprise, anger, and panic as I calmly addressed each complaint with documented facts and legal precedents. "Mrs. Whitmore," I said, standing near the back of the room, "you're asking a 150-year-old ranch to change operations for a subdivision built 3 months ago. That's like moving next to an airport and complaining about airplane noise." Several residents asked pointed questions about Karen's previous neighbor disputes. Her support evaporated faster than morning dew in August heat. The county planning office announced a review of the subdivision's permit compliance, triggered by all those complaints Karen had filed. Sometimes the best revenge is letting someone hang themselves with their own rope. Karen realized her media strategy had backfired. Her legal threats were toothless, and her community was turning against her. But like a wounded animal, that's when she'd become most dangerous. The real fun was just beginning. Karen's desperation led her to Channel 7's investigative team with a story pitch that would have made Hollywood screenwriters jealous. Federal employee abuses power to intimidate neighbors. She provided edited footage of our ranch operations, emphasizing dust clouds and morning feeding noise, claiming to represent dozens of affected families in her fight against government corruption. The smell of her own panic must have been overwhelming, because Karen was making rookie mistakes left and right. Here's where her media gambit exploded in her face like a faulty firework. Reporter Jake Morrison started investigating, but instead of focusing on ranch violations, he discovered Karen's trail of neighbor disputes across 3 states. The story shifted from problem rancher terrorizes subdivision to problem neighbor targets longtime agricultural operation. Morrison found building permit violations throughout sagebrush estates, documented Karen's pattern of harassment complaints, and interviewed former neighbors who painted a picture of someone who turned conflict into a career. When he called requesting an interview, I realized this was my chance to educate people about a bigger problem. I explained my actual federal role, HOA oversight, not ranch inspection, and provided documentation of Karen's escalating harassment. The timing was perfect. I mentioned my upcoming presentation to a congressional subcommittee about HOA accountability and federal reform initiatives. Karen's response was pure panic. Realizing her media strategy had backfired spectacularly, she attempted damage control by claiming she was protecting community standards against government overreach. She organized an emergency HOA board meeting to change subdivision rules and proposed a special assessment to fund legal action against our ranch. The community meeting turned into a masterclass in how not to win friends and influence people. Karen presented her slideshow of ranch violations with all the drama of a murder trial, complete with ominous background music and red arrows pointing at our cattle like they were criminal evidence. I showed up uninvited, perfectly legal for any county resident, and calmly dismantled every claim with facts and documentation. When Karen accused our cattle of creating excessive noise pollution, I pointed out that her own decibel readings showed levels lower than typical suburban lawnmowers. "Mrs. Whitmore," I said, the room silent except for the hum of fluorescent lights. "According to your own measurements, our cattle register at 45 dB during feeding time. Your neighbor's leaf blower hits 70 dB every Saturday morning." Several residents started asking uncomfortable questions about Karen's previous legal disputes. Turns out people don't appreciate being misled into potential litigation that could cost them thousands in special assessments. Meanwhile, my investigation into subdivision compliance was revealing fascinating details. Sarah Olivia discovered that when the original developer went bankrupt, all permit obligations transferred to the HOA. That included $340,000 in unfulfilled environmental compliance work that Karen's board was legally responsible for completing. The subdivision's HOA lacked legal standing to challenge our operations anyway. The original developer had included protective clauses for adjacent agricultural use, standard practice when building near existing farms. Karen's proposed special assessment required 75% resident approval, and support was evaporating faster than puddles in July heat. My federal training had taught me that many HOAs fail to understand their ongoing legal obligations from original development permits. When developers cut corners or go bankrupt, homeowners inherit problems they never knew existed. It's a nationwide issue that costs communities millions annually. Karen's allies began jumping ship like rats from a sinking vessel. Bryce Kellerman publicly withdrew from her Property Values Committee after learning about agricultural easements and his potential liability for permit violations. Donna Hutchkins quietly told neighbors she'd been misled about the legal complexities and was moving back to Phoenix. The entertainment reached peak absurdity when Karen attempted to measure our fence height with a surveyor's rod, documenting potential sightline violations. Our protective mother cow, Dolly, had recently calved and wasn't tolerating strangers near her baby. Karen's shriek could probably be heard in the next county as she fled, leaving expensive equipment scattered in the dirt. "Boss?" Buck called, barely containing his laughter. "That woman just got chased off by a mama cow protecting her calf. Even our livestock thinks she's a nuisance." Jake Morrison's preliminary article hit the local paper like a bombshell. Subdivision faces environmental compliance crisis. The piece detailed permit violations, financial mismanagement, and legal obligations that could bankrupt individual homeowners through special assessments. Karen realized her complaints had triggered the exact investigation that threatened her own property value and financial stability. Every noise violation she documented created evidence supporting our ranch's historical operations. Every agency she'd contacted was now scrutinizing her community's compliance failures. The county planning office announced an accelerated review of subdivision permits triggered by the volume of complaints Karen had filed. Environmental agencies were asking questions about drainage, sound barriers, and buffer zones that should have been completed years ago. Karen had spent months trying to prove our ranch was incompatible with residential development. Instead, she documented exactly why agricultural protections exist and demonstrated that her subdivision was the real problem. The trap had been set by her own hand. She just didn't realize she was standing in it. Sarah Olivia's title search hit the jackpot on a Tuesday morning that changed everything. I was reviewing federal HOA compliance regulations over coffee when she called with news that made me nearly choke on my first sip. "Garrett, you need to see this immediately." The documents spread across her oak conference table told a story better than any fiction. Sagebrush Estates' approval was conditional. They were supposed to establish a 200-foot buffer zone, install sound barriers, and complete environmental compliance work estimated at $340,000. The developer went bankrupt before fulfilling any of these requirements, legally transferring all obligations to the HOA. Karen's board was now responsible for every single compliance cost the original developer had dodged. The power dynamic shifted like tectonic plates. Every noise complaint Karen had filed created documentation proving our ranch's pre-existing rights. Every dust measurement she'd taken supported our historical operations. Every agency she'd contacted was now investigating why her community hadn't met legal requirements. The irony was delicious enough to taste. In my federal training, I'd learned about developments that receive tax incentives or federal funding like Sagebrush Estates, which automatically fall under HOA oversight jurisdiction. Karen had been harassing the one person in America with the authority to investigate her community's regulatory failures. Sarah's investigation revealed something even more damaging. Karen's house specifically violated setback requirements from the original permits. She'd built 50 feet from our property line when regulations required 200 feet. Her dream home was technically an illegal structure. "This gets better," Sarah continued, sliding another document across the table. "The subdivision's storm water management system relies on natural drainage through your ranch property. The original permits acknowledge this dependency. Restricting your operations could cause flooding throughout their community." Karen's vulnerability was complete. The property values she claimed to protect would crater if county enforcement action required compliance work. The special assessment to fund necessary improvements would be approximately $12,000 per household. Money her community couldn't afford and she definitely couldn't pay. I remembered my grandfather's advice about dealing with aggressive neighbors. Sometimes the best defense is letting folks tie their own noose. Karen had spent months creating documentation that proved our ranch was beneficial to the area while her subdivision was the real problem. The federal angle made it even sweeter. As a regional oversight director, I had the authority to investigate HOAs that failed to meet development obligations. I could recommend state intervention if communities couldn't address permit violations. My upcoming congressional testimony could feature Sagebrush Estates as a perfect example of HOA accountability failures. Sarah pulled out the final piece of evidence. Financial records showing the subdivision's HOA had failed to file required annual reports for 2 consecutive years. In federal oversight terms, they were operating as an unregulated entity while managing a development built with public tax incentives. "Karen doesn't understand what she's unleashed," Sarah said, organizing the documents into neat stacks. "Every complaint she filed helps us. She's documented why your ranch should stay exactly as it is while proving her community violated multiple regulations. The beautiful truth crystallized like morning frost. I didn't need to fight Karen directly. Her own actions would force her community to address real problems while leaving our ranch protected by law. She'd become the architect of her own destruction. Karen thought she was David fighting Goliath. Actually, she was Goliath falling on her own sword while David watched from a safe distance. The taste of justice was sweeter than Rita's apple pie and twice as satisfying. Karen's harassment campaign had triggered investigations that would either bankrupt her community or force them to spend hundreds of thousands fixing problems they'd ignored for years. All I had to do was continue normal ranch operations while Karen's house of cards collapsed under the weight of her own complaints. Time to assemble the cavalry. Sarah Olivia spread legal documents across her conference table like a general planning a military campaign. Buck Henley arrived with 40 years of ranch operation records, proving our historical precedents down to the day we first drove cattle down that disputed road. Rita Sandoval offered her diner as a neutral meeting ground and promised the best coffee in 3 counties to fuel our strategy sessions. Marcus Webb from County Planning brought the bureaucratic firepower, explaining how permit enforcement worked and agreeing to accelerate the subdivision's compliance review. Channel 7's Jake Morrison wanted exclusive access to our story as it unfolded. The man smelled a regional Emmy in the making. Our 3-pronged strategy emerged over Rita's legendary chicken fried steak and strong black coffee that could wake the dead. The legal track was Sarah's domain. We'd file a counter-complaint against the subdivision for permit violations, request county enforcement of original development conditions, and prepare documentation for my potential restraining order against Karen. As a backup, I'd ready a federal HOA compliance investigation, the nuclear option that could shut down their entire community governance. Sarah's research had revealed something fascinating about agricultural easements that I'd learned from my grandfather but never fully appreciated. These protections aren't just suggestions. They're permanent legal shields that run with the land forever. When developers build near existing farms, they're acknowledging that agricultural activities take precedence. You can't buy property next to a working ranch, then demand it stop working. The community track required more finesse. I coordinated with the Ranchers Association to show unified support at the upcoming county meeting. We arranged testimonials from longtime residents about our ranch's community value. People who remembered my father helping during the '98 flood and my grandfather donating land for the volunteer fire station. Local businesses were already rallying. Marty Kowalski documented how Karen's complaints affected his feed store customers. Dr. Sarah Martinez, our veterinarian, prepared statements about our exemplary animal care standards. Even the postmaster offered to testify about our road safety record, no mail delivery incidents in 37 years. We planned a Heritage Day at the ranch, showcasing our historical significance to the community. The smell of barbecue smoke and the sound of fiddle music would demonstrate what authentic Western heritage actually meant, not Karen's sanitized suburban fantasy. The federal track was my specialty. During my Washington training, I'd learned that developments receiving any federal funding or tax incentives automatically qualify for an HOA oversight review. Sagebrush Estates had received exactly those benefits, making them subject to federal accountability standards they'd been ignoring for years. I gathered data on HOA compliance failures for my congressional subcommittee presentation, using our local situation as a case study in development oversight problems. The timing was perfect. Legislators were drafting stronger HOA accountability measures, and real-world examples carried more weight than theoretical proposals. My federal colleagues were fascinated by the agricultural angle. Many rural communities faced similar pressures from suburban expansion, and our case could establish precedents protecting agricultural operations nationwide. The economic analysis was compelling. Our ranch provided $180,000 annually in local economic activity through feed, veterinary, and equipment purchases. Buck's security footage became crucial evidence. We had documented proof of Karen's daily harassment, measuring fence lines at dawn, photographing cattle through slats, following our supply trucks, and conducting what could only be described as agricultural surveillance.